According to the statistics by the Supreme People's Court, last 3 years, among 111 cases, application for the recognition and the enforcement of foreign arbitration awards, only 1 case was refused. The current global arbitration system is experiencing a new wave of reform and improvement as the economic center of global development is shifting to Asia-Africa. The position of arbitration development both in China and widely in this region is getting increasingly important in the international arena. Asia-Africa's arbitration institutions are therefore bound to play an even more important role in the future development of the regional and global economy.
I think as Nick has pointed out, the number of centers have grown. I think this is quite important because it's a testament of the emergence of Asia and Africa using international organizations as arbitral centers. There are 3 forms that arbitral centers can take. Basically, one is which is set up by, let's say, municipal, provincial, and central governments, which is basically the model that is adopted in China. The second one is the one which is set up by a company, a private company, limited by guarantee or a trust arrangement, which is the type that is in Singapore and in even ICC or in Hong Kong. And the third type is, of course, the AALCO centers, which is the international organization or international body under the auspices host in the country with immunities and privileges. The idea, I think, as Nick pointed out, is the Bandung Conference in the 1950s was aimed in a very difficult political era just after the war to bring together both Africa and Asia, and to some extent to deal with the decolonization that was going on at that time. So I think the importance of national independence and to promote peace at that time. And I believe that these principles still remain relevant. It remained relevant to our role as in dispute resolution institutions because peace is what parties look for other than time efficiency and cost savings. The ultimate aim of dispute resolution is to promote peace between the parties. So I've looked at the title of this forum, and I'm reminded of our shared history, our rich diversity, China, India, Asia, Africa, and more importantly, the values that we share as crystallized starting from the Bandung Conference. Today, I would always say that we are witnessing the Asian century and perhaps the African century. And there are many challenges to overcome. And this conference is timely for us, both in Asia and Africa, as arbitral institutions coming together towards a more cohesive partnership and benefit from our shared economic growth. Dispute resolution, there are new areas which niche disputes such as technology disputes, ESG, environment, social governance disputes, and even sports arbitration. We actually now represent the epicenter of dispute resolution in Malaysia. And we are hoping to emerge as a player in contributing to the global arena. This year, in August 2023, we introduced revisions to the arbitration rules, our mediation rules, and also we have one particular set of rules that not many people, many institutions have, which is the Islamic arbitration rules. We went back to our roots. We used the Ancestral Arbitration Rules 2021 as the base and amended it, institutionalized it by having the AALC arbitration rules, adopting and administering using the UNCITRAL rules. In third-party funding, that means we have disclosure requirements. Although we don't have any legislation in Malaysia to allow third-party funding, but the rules itself actually recognizes that third-party funding is a normal thing now in arbitration. Perhaps it will be a normal thing in litigation, and in our more advanced, more progressive jurisdictions like Hong Kong and Singapore, they have been dealt with in legislation. The other one is the I rules, the Islamic arbitration rules. We cater for the Islamic community, more of the finance community, where they are actually raising money in terms of bonds called sukuk and other kinds of instruments using Sharia principles. Now, one change that we are doing, we are going to issue a new set of Sharia compliant building contracts. That's actually, we are shifting towards compliance, going for dispute avoidance. Dispute prevention is becoming one of the important things, and I'll talk about it in ESG later, which is a more of compliance. And then the other thing is that we continue to maintain our diverse panel of arbitrators. We do statutory adjudication, one of the few countries in the world that we have a statutory adjudication team to deal with payment issues in the construction industry. The buzzword nowadays is environmental social governance, ESG, which is an umbrella term that refers to all kinds of environmental social governance issues and aspects of activity. ESG has become part of our lives. We have to deal with it. It is part of the Paris Agreement in 2016, adopted by 196 countries on climate change. And then I think, this is going to be the one that we in Asia and Africa will have to look at it carefully and deal with it. So I think one of the things where I believe arbitration will play a great part is that because arbitrators are independent with special ability, it is better than the courts. So I think, and again, the enforcement under the New York Convention of Arbitral Awards makes it almost completely effective. And again, you can actually even obtain interim relief and injunctions where there is irreversible environmental damage or gross. I want to talk about sports disputes. One of the things that is lacking in Asia and Africa, we are crazy about sports, or we will be setting up the Asian Sports Tribunal, and we will be empaneling arbitrators. I'm concerned about actually ethnic and nationality diversity. One of the things that we realize in Asia, while we produce the most number of disputes, for example, in LMAA, 50% of the maritime arbitration disputes in LMAA in London is actually Chinese, but I have not heard of a Chinese arbitrator on LMAA. So LMAA, I'm not aware. I think it just does call for more diversity in the sense that disputes coming from Asia, from Africa, not because it is we are xenophobic. There should be an opportunity for our Asian and African arbitrators to come up and decide these disputes.
Now, I'm going to cover a few areas. This is what Nick told me. I had to cover 10 points. So that's why I've gone through 10 points. One is the compliance and multi-tier dispute resolution clauses, interim measures relating to mainland China and also Hong Kong, governing law of the dispute resolution clause, the conduct of arbitrators, the importance of the notice of arbitration, the role of arbitration in ESG, as Dr. Sandro has mentioned, outcome-related fee structures for arbitration, artificial intelligence and technology and dispute resolution, adjudication versus arbitration within the construction sector, and enforcement and setting aside arbitration awards. But I'm just going to give you a flavor of why Hong Kong is pro-arbitration. The first one is, for example, relating to admissibility in jurisdiction. In this case, C and D, this case, there's a tier dispute resolution clause. Like most businesses around the world would like to reduce their risks. They don't want to go straight into arbitration straight away, so they might want to actually use negotiation, mediation, and adjudication before they go into arbitration. What happens in this case was that the parties did not follow the procedure in terms of the tier dispute resolution process. And one of the parties tried to set aside the award, and subsequently the court said clearly this procedure should be decided by the tribunal rather than by the court. So you can see that the court is supportive in Hong Kong about arbitration. Now, the next one relates to interim measures. This is a gift from mainland China to Hong Kong. And I think this is wonderful because this creates a situation whereby, for example, it prevents the respondents from attempting to evade their assets or their claims, for example, in mainland China, so that, for example, those who want to pursue arbitration have an assurance at the end of the day they're going to get what they want. So you can see that in terms of the bodies approved, there are 6 bodies in Hong Kong approved to do this. And in terms of applications, according to the HKRAC's webpage, there's 100, and 94 of those applications were made for preservation of assets, whereas 2 were preservation of evidence, and 4 were preservation of conduct, and assets totaling roughly 27.4 billion RMB. Now, and in terms of, for example, the other 100 applications, 96 decisions were issued by the mainland courts, 5 decisions relating to the preservation of assets upon the application provision of security, whereas 4 applications were rejected. So you can see that the courts in mainland China are also very supportive of this. Now, the next case I want to draw your attention to is this case in terms of the governing law of the contract. You can see that, for example, there are certain uncertainties about the governing law of the contract. And in Hong Kong, we've set the scene in terms of, for example, the governing law of the contract by following what a UK Supreme Court case said. And you can see that in China, Railway Hong Kong Holdings Limited, the basis says that the express choice of the governing law applicable to the main contract will generally also apply to the dispute resolution clause. So another case in Hong Kong relating to the conduct of arbitrators. And in this case, for example, this case relates to whether, for example, arbitrators are compelled to give evidence or to be basically brought before a court and so forth. But the courts in Hong Kong say that arbitrators are immune, subject to fraud and bad faith conditions. And these cases you can see are all very recent cases in Hong Kong. So you can see that Hong Kong is dealing with a lot of arbitration work. And also, for example, the courts, in a way, are supportive. But I'll tell you in a minute, the courts are supportive as long as you follow the procedures correctly. That's very important. It doesn't mean the courts in Hong Kong rubber stamp everything. It means that you have to follow procedures. So in this case, for example, CIC, basically, for example, the Court of First Instance refused to enforce an award because it's grossly unfair. The procedures were not followed properly. Okay? If the procedures were followed properly, the court would have enforced it. ESG. This is a topic, for example, is growing in importance. Information. And Hong Kong does have a climate governance initiative, basically whereby we're looking at, for example, climate initiative changes for Asia as well as Hong Kong. And I think that this is something that we can actually maybe focus on because, as our friend from Malaysia said, that it should not be just a Western sort of area they can focus on. I think maybe Asia and Africa should be focusing on this area because it has its flexibilities. Now, in terms of AI and technology disputes, there's a case in Hong Kong whereby called Sky Power Construction, whereby the whole case was done basically online, not in Hong Kong, but overseas, but in terms of enforcement in Hong Kong. And the judge said in Hong Kong, we can enforce it. So you can see, for example, even doing things totally online, the chances are you can enforce an arbitration award. Now, when did we start with AI and technology disputes? I think Nick Chen knows very well on this area, domain name disputes. We started this area with domain name disputes whereby WIPO was taking a lead on this, and so we decided to move into this area to see whether we can do it. And our friends from, for example, Malaysia, Korea, now hopefully Japan, and they will be working together, and also mainland China. The square trades and e-resolution and trading platforms, these were very popular around the United States and also Canada. And what happens is these developed, but they did not have the funding to actually move forward in terms of, for example, what they're providing. And of course, you can see that Alibaba is very active in this area in terms of online disputes. And also, I know that AALCO and also EBRAM, under leadership of our Secretary of Justice at the time, Teresa Chang, basically moved this forward because this is an important area whereby if you want to resolve disputes going forward, we might not have to have physical meetings or facilities, but at least online platforms to do so.
I will speak on the Kenyan perspective. To begin with, the substantive law in Kenya on arbitration is the Arbitration Act, which is modeled majorly, which is modeled on the ancestral model law on international commercial arbitration. The arbitral court is a creature of the Nairobi Center for International Arbitration Act, and the NCIA is one of the AALCO centers. It is established by law, and it has, since its establishment in the year 2013 and formal operationalization in the year 2015, has seen a tremendous growth of arbitrations, administered arbitrations. And the center has also, in addition to the arbitration rules, the center also has mediation rules that were enacted, that were revised in the year 2022. We've seen situations where a number of parties want to opt for mediation. So we've had instances where parties opt for mediation first, and then for the issues that cannot be resolved fully in mediation, those are the issues that are taken to arbitration. The center has also come up with conciliation rules for parties that wish to solve their disputes through conciliation.
The question received was, what kind of sports-related disputes can we expect to be resolved by these centers?
It can be all kinds of sports disputes, starting from matters relating to selection. And also, I think the other very important thing is doping. And then the third thing will be commercial sponsorship arrangements. So there are three different kinds, but it relates to whatever is the sports law is about. So any disputes that can be resolved by sports law can be arbitrated.
Anything to add locally? No? Dr. To?
I think we should be focusing on this. I think CAS had a meeting last month in Switzerland relating to sort of encouraging more panelists to be more interactive. I think this is something that maybe our Malaysian friend can take the lead on in terms of Asia and Africa, how we can actually move forward.
And I know the Law Society and the Bar Association of Hong Kong are also focusing on this.
And Christopher from Nigeria will be able to give us the perspectives from the Nigerian experience in judicial assistance.
New developments in Asia and Africa, including the legal framework and landmark cases in the relevant jurisdiction. I shall be concerning myself with the Africa jurisdiction, for this session. Now, judicial assistance in the process of arbitration varies from country to country. Some people see the involvement of courts as an interference, or in extreme cases, they see it as a hindrance. In other words, some people feel that by parties choosing to go to arbitration, they have indirectly decided to forego the national courts and rather put their trusts in the hands of a few chosen people who are chosen by them, and they agree to be bound by the outcome. And this is the principle of party autonomy, which we're all familiar about.
My presentation will have, my intervention today will have two aspects. First one, which is about the judicial assistant in arbitration, and second one will deal with the tech in courts. So for the first part regarding the judicial assistant in arbitration is obtaining support from national courts during an arbitration process. And we know that arbitration takes place outside the courts. So I would like to review the situation and the recent developments in Africa. We can find that judicial training programs, also harmonization of arbitration laws, and also facilitation of arbitral procedure as recent developments adopted in Africa. And of course, there is many case studies. I would like to provide some of them to show the recent challenges in this regard, the judicial assistant in arbitration. First one is Pro Electrica and Electrica. Here we find that the European Court ruled that domestic courts have the powers to take evidence via the Hague Convention despite parts dismissing arbitration clauses. And second case here is Renault versus Pan-Inter. We find that the Dutch Supreme Court acknowledged foreign law as a binding source of law in the Netherlands. Also, the third case is the court application by the Abu Dhabi National Company, where we find that the UK court under Section 67 granted assistance to arbitrator conducting a seat challenge and upheld the challenge. For my second part of my presentation, represented in the tech in courts, we know that the COVID affected many business around the world. And of course, the justice sector also affected by the COVID. And we can find many procedures adopted by the countries in this regard to find a solution. For example, changes in legislation, technical improvement. And I can mention here what happened in France, adopting what's called the Digital Republic to transform all the sectors to be digitalized. So the COVID pushed us to ask ourselves an important question, which is it the time to adopt technology in judiciary to improve the justice infrastructure in many countries as a UN Sustainable Development, one of the UN Sustainable Development Goals? Yes, of course, because here, according to this survey, to measure the trust in justice and the satisfaction of the user in the judicial system, we can find that most of the actors of the justice system are not satisfied about the court's performance. And here the Consultative Council of European Judges mentioned that information and communication technology should be a tool to improve the administration of justice, to facilitate the user access to the courts, and to enforce the safeguards laid down in Article 6 of European Convention of Human Rights, access to justice, impartiality, independence of the judge, fairness, and reasonable duration of proceedings. We found that the technology could affect positively on the access to justice because last survey did by HEAL, we find that about 11% of population are able to partially resolve their disputes, and only 31% have an ongoing justice problem, and unfortunately 22 find no resolution for their legal disputes or legal questions. Also, the technology has a positive side on the rights of people with disabilities. Here, Article 13 of the United Nations Convention on the right of a person with disability deal with this question.
I think the digital part is also particularly interesting. I noticed the penultimate point is digital justice must also be human after all. And I think so rightly encapsulate some of the points.
Expected to share some new development concerning judicial assistance in arbitration, particularly in the OHADA territory. And what is OHADA? OHADA is the French acronym of Organization for the harmonization of business law in Africa. And this organization was created by the treaty signed in Port-Louis, Mauritius, in October 1993, with the purpose to promote development of the contracting states by elaborating a business law which is simple, modern, and adapted in order to stimulate and secure investment in the OHADA territory.
Hong Kong has a specialist arbitration and construction list, which I think is another reason that gives us a real advantage in having specialist judges look at arbitration-related court proceedings. I would say that the Hong Kong court is very quick to protect and to uphold the parties' agreements to arbitrate. And we see this in multiple decisions, in decisions looking at the scope of the arbitration agreement, in decisions looking at what is arbitrable and what is not. And there was recent development a few years ago that with changes to the arbitration ordinance to make it clear, for example, that IP disputes are now capable of being resolved by arbitration. But that's really just the tip of the iceberg. There's a flurry of cases coming out from the insolvency courts about the interplay between public third-party insolvency proceedings and private consensual arbitration. But the case that I want to focus on is the C&D case. It's a 2023 decision. It went all the way up to the Court of Final Appeal, and I'll come on to looking at the appeal process. But that in itself, because it was seen as a question of real importance, my colleague Simon Chapman KC actually acted for the successful respondent in that case. And really, we see it as a really good example of not only the innovative way in which the Hong Kong courts approach perhaps slightly tricky issues relating to arbitration, but also the fact that I think Hong Kong is really at the forefront of international arbitration practice. At the tail end, we have enforcement, of course, often looked at through the lens of set-aside cases here in Hong Kong.
So case occur in Egypt, and this is unfortunately costs the government millions of dollars because here the judicial intervention and of national courts invoking jurisdiction in spite of the existence of arbitration clause. Yeah, this leads to many of cases in front of the international arbitration courts around the world, and finally those courts decided against Egypt with millions of dollars. But the situation is improved a little bit in the last decades in Egypt. To adopt judicial assistance in many of arbitral cases.
The theme of the forum is resolving differences in the changing world by staying true to the Bandung spirit. This session is all about resolving differences by way of arbitration in a changing world of new business methods and models like e-commerce and fintech by the use of new technology in the spirit of mutual respect, peace, and equality. Quoting from the Chief Executive's opening speech this morning, Hong Kong has a long and established tradition of the rule of law and is one of the world's top seats for arbitration. I'm very pleased to participate as the moderator in this session and shall be delighted to introduce to you the 4 speakers in due course. Now, we'll start today with the Mr. King Leung. He will start this session by sharing with the members and joining today the latest opportunities in fintech. He will cover wealth tech platform to more easily distribute alternative asset investments to broader customer segments, from HNWIs to mass affluent. Then he will speak about tokenization of RWAs, the real world assets, tokenized real estates, tokenized gold, tokenized IP, digital collectibles of mainland art and antiques, etc., followed by his discussion of Web3 development in Hong Kong. and its expansion globally?
I'd like to use 3 broad categories to illustrate to you about what are the latest developments in fintech. Now, naturally, when we look at Hong Kong, as you often talk to the senior officials in the Hong governments, if you ask many of us, what is that one KPI that will define Hong Kong? Well, one of them is the AUM, the asset under management for Hong Kong as a whole. And we are just very proud that in a recent BCG study, that Hong Kong actually stood at number 2 in the world, just behind Switzerland, as the second largest, what they call cross-border wealth management market. And by the year 2025, Hong Kong will surpass Switzerland as number 1. Now, so naturally, we'd like to build on that foundation by creating and inviting more AUM to come to Hong Kong. Now, the question is how? Now, so naturally, we take a very sort of humanized approach. If we were to invite more capital to come into Hong Kong, then what needs to take place? Now, in the interest of time, just highlight 2 things. And that's a very exciting piece of news that you might have come across, and that is the imminent launch of the stablecoins issuance license that will be launched by HMA sometime next year. Now, and why is this important? Now, again, without getting a lot of details, but if you do talk to the so-called crypto native, the digital asset native, they will tell you that this is a massive game changer. If Hong Kong can play our cards right in having the right, I would say, framework in issuing the stablecoins, then we have the foundation to so-called take over the future digital economy.
I'm very pleased to be amongst everyone to discuss a little bit about the core e-commerce offerings of Alibaba Group before going into actual disputes. So what distinguishes us is that we essentially want to create a cross-border network. So the kinds of law, speaking to all the lawyers here, is that we're dealing with multiple sets of law at the same time in our offerings. So we need to make sure that the whole supply chain is working, the cloud services, the data security, all the approvals, the customs, the levies, the taxes, the displays, the advertisement, even the guy who sends it to your door for signature, they're all working. If not, the typical user complaint coming back will be, I didn't get it, it was late, or it wasn't what I asked for, or I got this voucher and I don't know how to use it. These are the typical user complaints that we deal with. Does this require a court process or arbitration? Maybe not so. So in a commercial operation or e-commerce, I think the challenge is absent a class action, God forbid. And this is what we deal with on a day-to-day basis. 99% of what we deal with in terms of conflicts is to try to de-escalate and then deal with the user experience and operationally finesse the whole chain so that every step of the way is a matter of building trust. And the governing law and the arbitration provisions are very standard negotiations that a lawyer will have to handle, and our preference is really to always use Hong Kong law and Hong Kong arbitration. As I base my team here, and this is our commitment to Hong Kong as a hub, the international hub for Alibaba Group. Of course, before we have used Singapore as a backup because we also recognize the challenge that sometimes there is a stigma to a certain extent that if you put this in Hong Kong, is it China law? Like we will explain that this is not China law in the seat, and then the parties can agree. But I think in terms of the understanding by non-Hong Kong, especially international parties that we deal with, of how they understand that this is a world-class and very international body, which will be able to handle this level of conflict. This kind of mindset would continue to be need to broadcast it to international parties that we deal with. And finally, I think in terms of challenges on the next phase, what I have been contemplating is about artificial intelligence, because we're looking increasingly into generative content. King has very kindly talked about tokens and blockchains and all the fundamentals which support a higher computing power. Where we're looking at now are the usage scenarios where AI and a more complex data set, which are much higher competency in generating content, how these generative content, because it's automated decision making, will come into play in terms of evidence and liability.
Today, I will focus on dispute resolution. and I will want to focus on arbitration in particular. But before going there, my job is to explain what is IP and what opportunities that Hong Kong and China can offer in that field. So just looking at the statistics published by the World Intellectual Property Organization on the slide, now you will see that in 2022, of all the filings for patent applications, most of them came from Asia, and nearly 50% came from China, the State Intellectual Property Office. Now, on the face of it, this doesn't look very surprising, but only 5 or 6 years ago, the position as between China and the US was the opposite. So therefore, we have to understand that China is now the leading technology powerhouse of the world. And I'll explain to you how this came about and how in Hong Kong we are able to benefit from that. But before I leave this slide, perhaps the figures here show something deeper than just who files what and where. Because, I mean, why does somebody choose to file a patent in for example, China and not Europe, all right? I think the driving force behind patent applications is where people see their market will be, then they will go there and file a patent. So this reflects a view taken by technology innovators that China is the next, or is already the biggest market for intellectual property, in particular in the sphere of inventions. Now, so how does Hong Kong, how can Hong Kong capture this explosive growth of tech? In Hong Kong, we have a very pro-arbitration or arbitration-friendly court system. So that means the courts here tend to enforce and uphold arbitral awards, okay, unless something goes very, very seriously wrong.
I do have 5 cases. These are cases that we have handled, so they are real-life cases in recent years. Well, for confidentiality purposes, we have sanitized and we have made these facts a bit simpler. B is the investment arm of the local government in country X. Now, A and B agreed to set up a local entity to manage such EV supercars. A would provide the know-how, B would provide the funding, and officers from A and B would join the local entity as directors to make this a success. So everything seems hunky-dory, seems brilliant, but then COVID hit, and this caused a lot of disruption, and the venture became loss-making and broke down. Now, what then happened was that A commenced arbitration in Hong Kong, B then commenced court proceedings, its litigation in the local courts of that particular country X, although you might probably guess what that country X is, to declare that the JV agreement and the arbitration clause was void and alleged various fraudulent conduct. Now, this issue actually highlights another one of those benefits of arbitration, because what then happened, and you know, it is a reported case in Hong Kong, which we handled, is that we were able to obtain what is called an anti-suit injunction. This is an injunction which prevented Party B from either commencing or proceeding or continuing with the court litigation in country X, which would have interfered or made less beneficial the arbitration that we were handling in Hong Kong. So we did not want them to continue court proceedings, which could make life difficult, make it maybe more difficult to enforce any successful arbitration award in that particular country. But because there was arbitration and because the Hong Kong courts were hugely supportive. You heard about in the morning how interim remedies are granted in support of arbitration in Hong Kong, that we were able to obtain such an anti-student injunction to restrain the court action being undertaken by B, and to make sure that the dispute is and continues to be handled in Hong Kong.
A question for anyone on the panel. Which is your favorite place, dispute resolution forum?
Quick answer, please. Yes, Ernest.
Hong Kong.
Okay,
Yeah,
thank you.
Where we are.
CW.
AALCO.
And then, yes, King.
I guess I would take a non-legal, contrarian view.
Right.
I just hope that there will not be any disputes, because with smart contracts and the way that, for example, DeFi is designed, then there's no dispute. It's either A or B. I mean, the algorithm just trigger and get to the results, be it liquidation or something else.
Yes, thank you. Yes.
Hong Kong for us too, and if you take
Okay.
us online, we'll be even happier to do it because we're a cross-border business.
E-commerce developed very quickly. I think one topic that arose was about the online dispute resolution. How can we use the high technologies to facilitate the dispute resolution process? The ODR is the way forward. In January 2023, we are very pleased to see that APEC already made its excellent work regarding the best practices in using ODR. Some major points include the ODR must include a platform allowing the parties to resolve the dispute electronically. All communications should take place via the ODR platform. The ODR platform should include technical tools to help parties find a resolution without the help of a neutral third party. ODR should include the use of advanced technology such as AI. Last but not least, this document also mentions that ODR design must be user-centric with the following major principles: flexibility, efficiency, accessibility, affordability, usability, and capacity building. Apart from the UNCITRAL and APEC that I have just mentioned, we should also need to mention another very important organization, International Standardization Organization. ISO started work in coming up with a document regarding the transaction assurance in e-commerce, guidelines for ODR. The work has started, but still under development. So we do not have the final documents yet, but it's very important to note that the ISO indeed have put in a lot of efforts to produce some standards for ODR. It intends to give guidelines on ODR for e-commerce transactions, including basic principles of ODR, technical conditions and operational manuals for e-commerce operators, which aim to develop their own ODR services and ODR service providers that are outsourced by e-commerce operators.
The pandemic gave EBRAM a very good opportunity to test the ODR concept. EBRAM was established in 2018 as a not-for-profit law tech company and arbitration and mediation institute. By the time of the pandemic, a preliminary version of EBRAM ODR platform was just about ready for launch. We launched some of the early features under a specific set of rules under the complementary COVID-19 online dispute resolution scheme. As a silver lining of the pandemic, the development of ODR did benefit from the fact that parties and their lawyers had little choice but to try to adopt virtual means of running their cases. Given the conservative nature of the legal industry, it was a much-needed push to even get disputants to even consider ODR at all. Naturally, the end of the pandemic also meant that this incentive did not exist anymore. However, this does not spell the end of the road for ODR development. After the pandemic subsided and business returned to normal, EBRAM continued to develop ODR, and we launched the EBRAM arbitration platform and EBRAM mediation platform in February this year as two of the three main platforms where we support the use of ODR. The third platform being the EBRAM APEC platform, which was launched earlier under the corresponding EBRAM APEC rules. you have heard about APEC just now from Professor Zhao's presentation. EBRAM's ODR platforms now include features that help reduce the cost and ease the logistics of running an arbitration, such as the inclusion of machine learning-based transcription to transcribe video conferences in real time, machine learning-based translation to help translate both documents and transcriptions, and a document exchange and storage facility. EBRAM's ODR platforms can be complementary to proceedings, no matter whether such proceedings are conducted online or offline. With continued effort to tailor the tools on the ODR platforms to users' needs, and with further integration of new features that are demanded by users, we think ODR can continue to bring a lot of value to arbitration and mediation proceedings, even in post-pandemic times. There are many routes for taking forward ODR. Indeed, we often get asked that given the recent popularity of generative AI technology, like ChatGPT, whether ODR would integrate ChatGPT. We think that certain aspects of ODR can benefit from generative AI technology. For example, there is a potential for mediators to prompt the generative AI tool to generate further appropriate questions or discover additional relevant concerns for the mediator's consideration before the mediator approaches the parties. Another use case would be that generative AI tools can be used to generate portions of arbitral awards, such as the first draft of the procedural history section. However, we are also aware that there are certain concerns with using generative AI in these ways.
So when the pandemic comes, the whole world's arbitration center suddenly become online dispute resolution center. So as Dr. So mentioned, willingly or unwillingly, they have to do that. So that's a very good development. And even after the pandemic, ODR is still very attractive and very useful.
Recently, I had a mediation, which the introduction part was the parties were introduced to the concept of innovation and not limited by the areas of dispute. And actually, based on the innovative ideas of both parties, they were able to actually achieve a resolution within 15 minutes, although the whole half day was resolved. Why was that? Because you gave them the idea that this was mediation. It was broader than the area of the dispute that they were looking at. What are the public policies in different jurisdictions which would allow that? As again, which country gets ahead of this would be the jurisdiction where parties will tend to go to. And I think it's not just the laws, but countries, the way they formulate policies which will allow forum shopping in a way for those that wish to consider dispute resolution quickly. And the rate of pace of change and the rate of pace of business, if you have a business that's investing in technology, after 2 years is thinking, well, that technology is not going to work anymore. How can you afford to get into a dispute which may last 3 to 4 years? It's not feasible. So they're going to be looking at innovative ways to resolve the dispute quickly and move on with the next business, because by that time there'll be a new technology. Again,
I come from Africa, where digital divide is a reality. Do you think that online dispute resolution can be successfully experimented in Africa? Otherwise said, in a continent where insufficiency of energy is a reality.
It's not worthwhile. Probably the litigation fees will be much higher than the value in dispute. So that's why we are thinking probably we can come up with an ODR to help to resolve the disputes. And ODR, in a way, was introduced to try to protect the interests of the parties. So the consumers will say, okay, now we have ODR, which can really help us to resolve the disputes.
That also brings us to the APEC scenario just now. The entire OTR platform is very, very suitable to MSME dispute because of their size, of their limited resources, and relatively speaking, the amount of the disputes are not huge. So when you look at that angle, the one-stop shop online dispute resolution at present most suitable to deal with medium or small-size dispute where parties' resources are limited. But when parties' resources are not limited and the stake is high, if you do a survey, people are more willing to put more money into human resources, but they would also be prepared to pay money to use AI technology to help those human beings in running the cases. So that is the finding that we have. And I agree with Amarelli when we were doing all this use of tech questions and brainstorming and all that. Ultimately, I think the question is how easy your product is for your target users.
Proud as AALCO, we are with the assistance of Ibrahim, we have developed our own online dispute resolution. I think this is a very successful collaboration model that can be replicated in other arbitration institutions in Africa, maybe in other world, in other jurisdictions as well. So that's my brief comment.
One of the fascinating features of the Hong Kong market is that we are producing rules for companies that are listed in Hong Kong, but almost 80%, I think, of market cap is certainly coming out of PRC. And so therefore, having rules that PRC companies can't immediately meet would cause us huge problems. So we're trying to have a foot in the sort of international side of things and meeting international investor expectations, whilst also making sure that we do things that align with the requirements and the rules in PRC, and trying to effectively bridge both of those two sets of requirements can be something of a challenge at times.
I think ESG is now taken like a given. Right? Everybody say, well, it's popular, it's recognized, it's acceptable, it's welcome, it's best practices, and so on. But actually, the debate is still going on as to why we put ESG together, and why in that order, E, S, and then G. And then whether the cost effectiveness of ESG reporting is really good or not yet, whether it can reflect social impact or impact on the environment. And there also has been criticism about an overemphasis on investor required kind of information, rather than stakeholders, and much more emphasis on E rather than S and G. We need more ESG guidance or radar in order to channel more ESG fundings faster to ESG projects. And in that journey, we also have to deal with problems such as greenwashing and also data integrity, because to do ESG, you need to have fintech solutions. And that means you need, to deal with a massive amount of data processing, management, and analysis. And so that you can provide solutions, applications such as, certification, disclosure, monitoring, tracking, red flag reports, and so on and so forth. It's a lot of data and a lot of ratings we will produce. So bad ratings or questionable ratings may lead to bad decisions, and then people say, this is a green project, but it's not. Then a lot of data problem, garbage in, garbage out. So the integrity of data is very important. So in the future, the data solutions and the quality of the data, the integrity of data, and data governance is a big issue. So there'll be a lot of disputes for sure, and people will argue about what is good data and why I made that decision based on such data, because it will be a very important decision. It will be real money being invested in projects or companies. So I think at this juncture, I like to say that no matter what, it's too late to debate. Now, ESG has arrived.
I'm pretty sure it's only a matter of time for China to have a more ESG arbitration cases. Well, last session was on ODR. It's very interesting. My understanding is ODR is important in that it saves a lot of time and cost. But one aspect in relation to ODR is that it also very environmental friendly. So there's some discussion in the arbitration circle on interrelationship between arbitration per se and the ESG. So basically, people are saying we should make hearing virtual. So there was a study, I think, by Herbert Smith last year on the comparison of the carbon footprint between virtual hearing and in-person hearing.
In Hong Kong, we see increasing awareness of and proliferation of ESG issues. It's clear that there will be increasing regulation in the ESG space. If you create new obligations and rights, then inevitably this will increase the potential for disputes to arise. If you build new regulatory structures, then risks arise regarding non-compliance and disputes will follow. So to borrow from that film, A Field of Dreams, which was about building a baseball field for an imaginary team of baseballers, if you build it, they will come. Businesses will either adopt good ESG policies or they will not. And the failure to adopt good ESG policies will likely impact a business's ability to attract and retain top talent, but may be unlikely to give rise to a large range of disputes, or at least disputes on a large scale. Operating from green buildings, in other words, ensuring the building is sustainable and minimizes negative impacts on the planet, will be a significant factor in attracting talented employees.
You can't have a sustainable company unless you have a sustainable planet and a sustainable community in which that company operates. And there is no larger issue for sustainability that exists today than climate change. It is almost impossible to win the war for talent in a very tight labour market with a young workforce if you are not having an appropriate position in relation to climate. We are now seeing customers much more willing to pay a higher price for a product which is carbon-free. And it's not just supply chains, we're seeing it from banks with green finance. It's got covenants in there that require companies to meet certain climate-related attributes or targets. Insurance companies require representations along a similar line, particularly for us at the pointy end for the coverage of the legacy coal generation assets that we have in the portfolio.
I think for supply chain dispute, there's a possibility of a contractual cascading.
It's a sector-focused discussion and it's trends of mega infrastructure projects. Now, I think in the current era, there are a number of major infrastructure projects, from rails to highway projects to ports, that are being constructed around the world, especially, if I may say so, in Asian and African countries. And they could be from contractors and investors from Asian and African countries, but also from the Western world that perhaps are investing in these projects.
History is a mirror. It can help us to summarize the past and to predict the future. So first of all, please allow me take a few minutes to briefly review the history of Chinese participation in international construction business. The China Construction Engineer Corporation was the first Chinese company established in 1978, specialized for the offshore construction project. So on one hand, it will become necessary for more international arbitral institutions, such as AALCO, that can handle both commercial arbitration and investment arbitration, to actively participate in dispute settlement, as the Chinese constructor has changed from a traditional contract to a project financing operator or even an investor. There will be more application of China's standard in such mega project.
作为在中国大陆和香港两地上市的企业，我们立足香港30年，如果说选择仲裁，能在香港进行仲裁，当然是我们最主要的考量因素。我觉得除了香港，除了刚刚说的一般的仲裁机构所具备的优势以外，在香港进行仲裁还有3个特别大的优势。第一个，优良的国际法治环境。香港是国际金融中心和商业枢纽，背靠中国大陆，连通世界，具备超级联系人的角色，有丰富的法律和专业资源，并且相对独立、透明和稳定的法治体系。在香港的仲裁效果，在全世界能够受到广泛的尊重，并能够得到认可和执行。第二个，相比其他地方，香港有多元化的专业仲裁机构选择。目前，包括亚非法协、香港区域中心、香港国际仲裁中心等多项选择，可以赋予当事人更多的选择。第三，我想特别分享的是，作为中国的企业，地位的提升、话语权的增加，也是我们能够自由选择仲裁方式的重要考量。随着中国几十年的发展，已经走上了世界的舞台中央。作为中国企业的一份子，我们更感受到了在国际化的过程当中，我们可以更加自信的在商业谈判当中能够选择我们自己的合理的诉求，包括正义解决方式的诉求。我认为这个对我们这种企业来讲是一个特别重要、最重要的因素之一。以前我们是学习者，我们是跟随者，所以我们在商业谈判中没有选择。但是现在我们可以自信地说，看看我们中国的企业，我这个企业是全世界至少中国最大的公共码头服务商，我们20多个国家地区50个港口码头，我们1年的利润能够几十亿，所以我们有可以自信的去做商业的谈判的选择，包括仲裁地的选择。相比其他的仲裁机构，我个人的理解，亚非法协香港区域仲裁中心它本身还有3个优势。第一个，各界的鼎力支持。亚非法协香港中心得到了中国中央人民政府和香港特区政府的大力支持，受亚非法协成员的充分肯定，具有香港特区承认的类似国际组织的独立身份，在资产、档案，包括仲裁文件等方面有不受侵犯的特权和豁免。我认为这个也是个非常大的优势。在国际竞争、在数据保护、在各种这个情况下，我认为这一点优势也是非常值得大家考量。
Well, in our standard conditions of contract here in Hong Kong, we have a multi-tiered dispute resolution process. Firstly, with submission of a dispute to the engineer. Secondly, with compulsory mediation, although of course you do need both parties to play ball. And thirdly, with arbitration. But we also use a number of non-contractual processes, and I'll come on to give you a few examples of these. Senior party negotiations, for example, or a non-binding, without prejudice, third-party assessment, particularly to consider a specific technical issue that's arisen and is really causing a challenge between the parties and inhibiting their ability to come together and resolve the dispute. So why do we go for this multi-tiered kind of approach? Well, it enables you to use separate and distinct appropriate dispute resolution mechanisms as the dispute escalates. And it really acts as a filtering system. So some of the less complex disputes or issues can be resolved at an earlier stage and a lower level, leaving only the really challenging disputes requiring more extensive procedures, extra time and cost to be resolved in a forum like arbitration, with a view, of course, to saving the parties time and cost with minimum disruption to the projects. Because I think, for me, that's one of the key factors behind trying to resolve disputes on mega infrastructure projects, is that the interest of the parties is to get the project delivered.
AALCO is an international organization recognized by the UN. And so whilst it is not set up, the arbitration centers are not set up by treaties, they are arbitration centers that are actually backed by an international organization that has 47 member states, and their neutrality and their internationality, as well as the uniqueness, the privilege and immunities that are given to these bodies become extremely important when you are choosing arbitration.
And because of the Cold War, and because the world has become a more difficult place, we have things like sanctions. And sanctions, in fact, come in so many different forms. We have, of course, the UN sanctions, which are highly focused. And at the moment, there are only 15, in fact, sanction regimes, which was approved by the Security Council. And they are very heavily policed by committees under the UN. And they, in fact, have short leases of life. And so long as the policy objectives are completed, then these sanctions are cancelled. On the other hand, we have different states, in fact, now involved in imposing sanctions on other people. And of course, the state that does this the most, mainly because it is, of course, the economically most dominant state, is the United States. But of course, the European Union also does that.
Hong Kong has been a very important player because Hong Kong has inherited all the technical know-how from Shanghai, okay, during the 30s, 40s. That we gain a lot of the technical know-how in textile and garment making, and also another group is from Guangdong, and it makes Hong Kong become a big textile hub. And we have been, because we are more international, we are able to sell products to US, to Europe, and be able to negotiate with customer and to deal with all these sanctions and the government and the politics. If US is not very good in terms of how we serve the market in our industry, let's look for other markets. Mainland market, China market, in Southeast Asia. So these are the opportunities that we also see outside of sanctions. We just need to learn to live with sanctions.
And I think number one is for us that are with the corporate DNA from financial industry foray into a new industry, right? We need to learn and swim very fast, right? If you have 31 countries, freelancers working for you, how much knowledge you have across different labor law in different markets, that would be another like a hat that you need to understand, right? And number one, if you are running in a global business or you intend, right, to expand your business in multiple markets, IP, trademark is something that you need to really take up as your top of the priority when you're foraying into this, right? Because that not only just about protecting your own logo, it also stands your evidence of ground in operating in that business.
That is a series of change from the supply side. If there is any one of your suppliers that's have got sanctions, that may serious impact on your own business too. So we always advise our global clients that we need to know what kind of the sanctions and also any specific rules is related to your business sectors. We need to manage the risk. How we can have a better planning if there is something happens, how we can manage is that. And what I mentioned before is that the second part is talking about the cybersecurity. The cybersecurity is also very important because every company now is talking about whether there is any hackers, what your business is doing, if there is any hackers in your business, or your data leakage, how you have the customer privacy, how to protect your data.
You could imagine that for all foreign affairs, foreign jurisdictional affairs, it will fall within the ambit of the Central People's Government of China. However, we do have two local legislations which effectively implements only the United Nations Security Council sanction regime. And the SWIFT ban has a profound impact. Although it doesn't really, you say that it's disconnecting the Russia, but it prompted a lot of thinking as to what if a country beyond Russia is put on, similar prohibition and got disconnected. And if you look at the SWIFT membership, they have over 11,000 participants. And there are over 600 PLC banks connected to SWIFT still. And so the issue is, although the Russian sanctions are adopted in the US, in the EU, in the UK, they do not form part of Hong Kong law. But because of the banking system, the SWIFT ban, we do have, in your day-to-day operation, you need to bank with different banks. And the banks, they are subject to, global compliance regime, including they need to observe a lot of the US sanction because of the connections to the SWIFT. So I think the SWIFT ban does impose significance or reflection about individual countries' contingency thinking in response to the SWIFT ban. So what are the key considerations that you may consider in addressing the sanctions issue? As I mentioned, I think the sanctions regime involve multi-jurisdictional, highly complex, and even for international legal firm like us, we have to have multiple sanctions specialist team located in different jurisdictions that we operate. So whenever you onboard a new client, a new matter, you need to conduct a very thorough assessment about the potential nexus. You need to ask yourself whether there's any indicators about nexus to the sanctioned countries, sanctioned persons, and you need to go through screening process about your counterparty, the ownership chain, who are in control of your counterparty. And you need to do due diligence, on your counterparty, your supply chain, as all the other speakers have mentioned. You need to reassess your contractual arrangement to see whether you've got contractual terms that enable yourself to early terminate.
Now, the theme of this particular session is dispute resolution in Asia and Africa, the way forward. Now, there are three aspects to it. To provide an overview of the trends and new developments in arbitration, mediation, and adjudication in Asia and Africa, to explore further what should be done by the international communities, local governments, arbitration institutions, and professional bodies to maintain the healthy and robust development of the ecosystem for dispute resolution in the Asia-Africa region, and lastly, to address the capacity building of arbitration talents in Asia and Africa.
So, in the CCG arbitration system, the administration is made up by the lawyer specialized in ADR, whereas the control is made by the court in its jurisdictional function. This is the innovation I wanted to stress. But there is a specificity in the CCG arbitration. That is, once the president of the court or the judge delegated by the court grant exequatur to the CCGA award, this makes the awards binding and overriding on the whole OADA space, whereas outside the space, the recognition of this award will be sought with the New York Convention.
In my view, number one, competencies of the parties, their legal representatives and experts in such arbitration process. The readiness and willingness of arbitrators to be more direct and interventionist when there is a clear and significant imbalance of power between the parties. Third, the necessity of additional safeguards of some arbitration cases, if appropriate. For example, when an arbitration is involving a state or the amount of the case is large. I think in conclusion, enhancement of arbitration and dispute resolution mechanism is certainly essential, and any proposals and recommendations thereon are needed in particular for the continued success of the Belt and Road Initiative and the fostering of international cooperation among Asian and African countries.
Now, speed is also very important, and this is something which I think Hong Kong does quite well, which is that the judge in charge of the arbitration list is willing to deal with matters very quickly. Because, of course, at the end of the day, if you've got your award, you want to get your leave to enforce. And if somebody wants to set aside, you don't want this to be dragging it on. In 2016, her ladyship, in one of the first instance judgments, said this. She says, "It has been emphasized by the Hong Kong courts that the object of the arbitration ordinance is to facilitate the effective and speedy resolution of disputes by arbitration. And the primary aim of the courts is to facilitate the arbitral process and to assist with the enforcement of arbitration agreements and awards as mechanistically as possible. This, however, should not in any way be seen to undermine the importance of due and fair process and the fundamental safeguards which must be observed to ensure that no injustice arises out of the arbitral process or the award." Now, in Hong Kong, we also have registered foreign lawyers. So those are lawyers admitted in non-Hong Kong jurisdictions. And I think it's important because it means you have that rich ecosystem to support the arbitral process. Hong Kong is an incredibly open legal market.
Hong Kong is always pro-arbitration, and we are doing everything we can to make sure that we maintain the status as the arbitration hub in the world, or at least one of the leading arbitration hubs. If you think the arbitrator made an error in the law, you can appeal. Otherwise, facts you can't, right? But as a good lawyer, everybody can build up some argument to say that the arbitrator make some errors in the law. And so, in those days, all cases went back to court, and then the court was so annoyed. They say, look, arbitration now has become, the court has one more level. Do you see what I mean? Right? It's nothing but one more level of, you just go for a trial and then before you go up. So why should they keep, come on, go back, don't come to the court, otherwise don't do arbitration. So this has always been Hong Kong's attitude.
AALCO is an important organization that promotes development. And I think the creation of this regional arbitration center is part of this idea.
The interim measures is very important in terms of, preservation of assets, evidence and conduct. And yes, I do have the statistics. As at the October this year, the total value of assets preserved by 71 decisions issued by the mainland courts amounted to approximately US $2.2 billion. Regionally, there's much more to be done. For example, in GBA, because it's one country, two systems, three jurisdictions, a lot can be done in terms of once there are, cross-boundary disputes, you need to resolve them, and you need to resolve any agreements. For example, mediator settle agreements.